around 9:30. And I hopefully be back by 10:30, quarter of 11.
Where do you go?
I'm going to actually the Southern Vermont College gym, which was just purchased. The old campus was just purchased by the hospital, and they turned the athletic facility into a vaccine site.
Okay, great.
It's really nice, actually. Very well.
Good.
Okay, so we're live.
All right, good morning. This is Senate Judiciary Committee. And we're finally at Friday, the 19th of February. That means we've got 2 weeks left before the crossover deadline. I do want to mention a couple of things. Reading Alan Keyes's article in Vermont Digger this morning, and I just wanted to, regarding S11, the robocall bill, and I wish I had responded to Senator Benning, something to the effect that just like the NFL, legislators, state legislatures are kind of copycat leagues, and enough states stick up and take action against robocalls, maybe the feds will get the message that enough is enough. And I was pleased that the Attorney General and the Department of Public Service both support the bill as providing a tool for their toolbox. While I agree with Senator Benning, there may be little action here on the state level. Sometimes we get the attention of others. And then on my own comment about charities, I wasn't clear as I should have been that what I meant was that most charities that do fundraising through robocalls are either scams or they are charging an excessive administrative fee in order to conduct the fundraising. And that was my experience based upon a bill we did several years ago requiring charities, when they send you a letter to asking you for money, and I don't know how many of them follow it, but asking for money, that they put in the administrative costs of doing the fundraising so that people are aware. And there were cases back when we did this bill, which was probably a decade ago, where administrative fees were in the 90% range of what is funded. And as much as that's unbelievable that that would happen, it did happen with two different charities. One was the Sheriff's Association fundraising one year, and the other was a memorial at the firefighters training site in Pittsburgh.
So I got a Social Security call last night with the recording. Social Security Administration, there's a problem, da-da-da-da-da. And at the end, they said, press 1 to speak to an agent. I was sitting there bored. I said, okay, press 1. As soon as this woman came on, it was a room full of people that were with her talking on the phone to various places and quarters. And I just said, I really don't believe you're part of the Social Security Administration. Click. That was that. I think I was kind of taken aback by how Digger reported the story. I did ask at one point for David to come back and talk more about the tool in the toolbox. And I understand why they would like to have the tool in the toolbox. I didn't want it to come across sounding like we were wasting our time.
I appreciate that, Joe. I just wanted to clarify it. You know, I'm not criticizing the story one bit. It was accurate to what I said. And just wanted to clarify. So, anyway, we're taking up that was S11, which I thought we were taking up this morning. And we're actually taking up S45, the probation bill. So Bryn is here with the latest version.
I am. Good morning, committee.
Good morning.
Good morning.
Morning.
So I'm here with draft 4.1 of S45. And for the record, it's Bryn Hare from Legislative Council. And I will share my screen with you. Can everybody see that at the top of the page? It should say
Yep.
draft 4.1. Okay, great. So there are just a few changes made to this draft, so we should be able to get through them pretty quickly. The first one is in section 1, the purpose of probation. We took out the word thereby after much discussion. And then I'll jump down to section 2. This is the directive to the sentencing court once the commissioner files a motion. And you can see that the change here was made based on the suggestion of Judge Grierson that there be a timeline imposed for when the prosecutor has to file that motion to continue probation. So we've made it within 21 days of the prosecutor's office receiving the notice of the commissioner's motion to discharge.
Is there any comment on that change? Everybody okay with that, including Matt Valerio, James Pepper, Judge Grierson? Anybody else is here?
I'm fine with it.
Go ahead.
Yeah, I think it's okay.
Okay. So I'll keep going.
Yep,
Senator?
please.
Okay. So scroll down to the 2 criteria, and we've made a change here so that now this language reads that if either the court has to either make a finding by preponderance of the evidence that termination will pose that risk of danger, or the court has to make a finding by clear and convincing evidence that the probationer isn't substantially in compliance with those conditions that are related to rehabilitation or victim safety. So we've got 2 different standards of proof here for the 2 different criteria.
Good.
Either one of these things, along with a motion to continue the probation, would result in a denial of the commissioner's motion to discharge.
Okay, everybody, any problems with that from anyone?
Okay, and then there's just one other thing, which is all the way down here in section, in section 3. These are the criteria of the department has to find, and we just replaced the word program with services there at the request of the
That was a request to the Department of Corrections, am I correct?
correct.
Any comment on that?
May I
Yeah,
ask a
sure.
question about that?
Yep.
So they have to have completed any rehabilitative or risk reduction services, the duration of which are set and knowledgeable at the outset. Okay, so it isn't just ongoing therapy.
No, if they say, after they do the crash program that you need to participate in something else, you may have difficulty getting your license back, but you would, as I understand this, you would then get off probation.
But so it says the duration of which are set and knowable at the outset. I don't think that the IOP programs have a set time. I think that the duration is not necessarily known. It depends on
What's an IOP?
Intensive outpatient service program.
Oh, yeah.
And if you're saying that they have to have completed that, but my understanding about them, because we had them here at the retreat and then they canceled them, AHS thought it best not to have it available here anymore. So we don't have any of those services anymore. But the IOPs, as I understand it, are they aren't set for a certain number of weeks, is my understanding.
Then they wouldn't be eligible, then they wouldn't come under that.
I just wondered because I think Dale
Is that the idea,
mentioned
Dale?
IOP service.
Do you understand the question, Dale?
The way that I would interpret that and apply it is that if someone is engaged in an IOP or mental health services or anything of that nature, that as long as they're in compliance, we would submit the discharge. I would only I'd view the current language as someone that's in something that has set timeframes.
Okay.
Like durations, like crash and BIP are probably the two
So
that come to mind.
the others that are kind of don't have a set duration and stuff, they would be just if they're in substantial compliance.
Correct.
Okay, great. Thanks.
I guess and correct me if I'm wrong, Dale, I would look at this as a person who's completed the set battery intervention program And if they decide, if the decision was to go to alcohol rehabilitation services that weren't known at the start during the battery intervention program, as long as they completed the battery intervention program, they would be eligible for discharge and not have to wait until they've completed all the alcohol.
That would be my.
Maybe a lifetime.
Yeah, probably would be a lifetime.
That would be, is that what we're doing here? In your
That's the way
mind?
I would view it. Correct.
Okay.
Anybody with any other comments or questions about that section? Thank you.
And
Um,
that's it for the changes to this draft.
and that's 4.5?
4.1.
Oh, it's 45, 4.1.
Yep.
I would entertain a motion to report favorably as amended draft 4.1. Or no, to amend the bill as seen in draft 4.1.
I make a
Senator
motion,
Nicka, yeah,
I make a motion to amend the bill as changed, to vote to positively to vote the bill as amended in
Thank you.
draft 4.1.
4.1. Senator Nicka has moved that we report favorably, that we amend the bill as seen in
Yeah.
draft 4.1. Is there any further discussion from either anyone in the audience or anyone on the committee? Hearing none, Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. I assume that there's a motion to report S45 as amended in draft 4.1. Senator
I'll move
Bruce
that.
has so moved, and
Okay.
Senator White has seconded. Is there any further discussion from anybody in the audience or anyone on the committee? Hearing none, Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. 500, and I'd like to report the bill. But I want to commend the committee for the fine work on this bill and all of the various players from Judge Corsone's. There is a Judge Corsone.
Mhm.
Judge Gerson, the Defender General's office, the Department of Correction, and the state's attorneys and the Attorney General and the Center for Crime Victim Services and other groups who worked on this bill. Thank you very much. Peggy, is there a way, did you check with John Bloomer, a way to send this electronically to all members of the Senate as part of the report on S45? Normally, we would put this on their desks.
Yep. What are you referring to? What is it?
I'm referring to the Pew study, December 2020, states can shorten probation and protect public safety.
Okay. Can you,
We've all got it.
okay.
Bryn,
Can someone
maybe
send
you
it to me?
did. I think you already have it, but it may have been posted on our committee page.
Okay.
I'm just wondering how to get this to every other senator so
Yep.
that during the report on the bill, I can reference this.
Yep. I'll talk to him about it. No problem.
Yeah, 'cause normally I would put this on everybody's desk.
Yep. And Bryn-
Obviously, I can't do that during a pandemic.
Yeah, we can do that. Bryn, will you send me the after it goes to editing?
It's been edited and I just saved it without the highlighting. So if you just use that document number, you can send it.
Okay, awesome.
Pull it up and send it.
Great.
And can we all get it too when you get a chance, Peggy, please?
Yep. Sounds good.
And Senator Nick, Senator Kitchell called me this morning. I don't know if you heard the conversation while you were logging in.
No, I was on another.
Regarding the Budget Adjustment Act, she would like to, on the floor today, say that we concur. There were two changes that impact the judiciary. or the Judiciary Committee. One was on the, oh, they're both on, one was on the use of force training. And it makes clear in their amendment, which is how it works anyways, that any money left over from June 30th, 2021 would be carried over to the FY '22 budget. Senator Ruth, did I miss?
Well, the only thing I'd add is that it also says that any training would have to be done according to what is in law July 2021. So they're clearly still seeking to move the date out. And they want the money not to be an argument to train under the current law. That's the way I would put it.
And the second is on the body cameras. They want to report back to the various committees. Which, I mean, anybody could just ask, well, how's it going? I thought it was a bit picky, but I told Jane that I was okay with it.
I was okay.
There's an email that you would have. If you could just let Jane know you're okay with it, or if you oppose it. When she talked to me this morning, she asked me to bring it up to both you and Senator Ruth.
Okay, thanks.
Okay. She wants to get up on the floor and get rid of it. Also got the labor thing that Michael sent back to his committee on the 1099 mess up.
Oh, okay.
They put that in there.
You put that in there? Okay.
All right. And Bryn, you will get me a report for the
Yep.
floor so we can go over how the bill operates.
I sure will.
Thank everybody very much. This is a key part of justice reinvestment too. And it should have an impact on the number of people that remain on probation, and should, I think, maybe even more importantly, it'll bring some geographic equity to around the state and how cases are dealt with.
And not only that, it's good policy.
And not only that, it's good policy. Thank you, Senator. All right, the next item is 39, which is a simple little bill. And there is a letter. Pat Gable wasn't able to be here, but she's written a letter. And the basis is, yes, they would be willing to tell us what the fees are, but it's a constitutional issue, and the fee report under section 605A is not the appropriate vehicle. That the Judiciary has the right to enter into contracts with Tyler Technology or others. And so anyway, Rebecca, maybe you could go over the bill, and unfortunately, Pat Gable wasn't able to be here.
Sure. Good morning, Becky Wasserman, Legislative Counsel. I can, would you like me to share my screen?
Yeah.
Or do you have, okay.
We've got copies, but
Is that a size that everyone can see?
That's good.
Okay. Okay, so this is S39, which is relating to the judicial branch's fee report and electronic filing fees. And so for some context, this section of law in 605A and Title 32 says that beginning 2011 and every 3 years after that, the judiciary has to submit to the legislature their fee branch report and request. And what goes into that is not just like new fee changes or requests. It's any it's any fee that's in existence, and it's what the statutory authorization for it is, what the rate amount is for that fee, what revenue has been derived from it. And then also in that section, there's the any request for a proposal for a fee. So that includes creating a new fee or changing one or terminating a fee, setting a new rate from an existing rate. So it's sort of informational and also gives the legislature, which has the authority to set fees, the ability to sort of approve that fee. The judiciary, so the executive branch does this, the legislature and the judiciary, they all have fee branch requests that have to be submitted to the legislature on a schedule. There are some fees that are excluded in the executive branch side, for example, and those are, there's a list of them in statute of what they are, and they're more like administrative types of fees, like transcripts. The judiciary also has a section of law that allows for the justices of the Supreme Court to, and this is in 32 VSA 1403, under rulemaking power, to establish rules to govern fees not specified by law or services and expenses in the court of the state. The e-filing fee was set per, I think, the judiciary's testimony under this other section of law that allows for the justices to set fees under rulemaking power because it's not specified elsewhere in law. What this bill is doing is requiring, and I'm just going to jump to the language here on page 2, sort of notwithstanding any other provision of law, requiring that the judiciary's fee report and request include any judicial branch fees associated with electronic filing and any proposals to reauthorize, change, or terminate any judicial branch fees associated with electronic filing. So this is effective July 1st of 2022. Part of the reason that date was picked was because the 3-year schedule and statute for the judiciary to submit their report. Although we haven't really had a fee bill in a while, I think the next judiciary report would be due in 2023, January of 2023. So this is going into effect prior to when that would need to be submitted. So this is saying that after that date, when their next submission comes due, that they have to include in this report sort of what the status of that electronic filing fee is, what the rate is, and if there's any proposal to change that fee, that would go through the legislature.
So we talked about, before I introduced this, I still think that we have a right on the fees, and the judiciary disagrees, or Pat Gable disagrees. One might ask, is it constitutional? Do you have any opinion on that?
Well, I think the rulemaking authority section that well, there's a couple things. There's the executive branch section that excludes fees for more administrative costs has a list that makes it clearer what is included under that. The judiciary's rulemaking authority section about any fees that are not otherwise specified by law does not have a corresponding list to sort of make it clear what is meant to be covered by that rulemaking authority. But there is pretty clear law in section 602 that says that, you know, the legislature is the one who has the authority to set fees and set a uniform policy of fee making. So I think that the judiciary's rulemaking section, without really specifying what is included in that, is a bit in conflict with the other section of law that says that this is the legislature's purview. And with that sort of policy statement about the legislature being the one who sets the fees, I think there could be an interpretation of the rulemaking section for the judiciary that it's meant to cover more administrative type of fees, such similar to what the executive branch is set for in the executive branch section, although that is not clear. That is not, that's an interpretation based on reading all of those sections together. I think so. I think that because there's a contract in place, this obviously makes it more complicated. And the judiciary does have their right to contract, and I think that there is a constitutional issue potentially with impairing the contract that's in place. But I also understand that that contract is up for renewal. So I think that if the legislature can sort of require that we say, you know, what's under that section of law that says not otherwise specified, well, now you're going to specify that electronic filing fees should be covered under the fee branch report. So I think that this doesn't impair a current contract, because it's not going to be in effect for another year or so, but I think it does allow the judiciary to take this into consideration when negotiating a new contract
with anyone.
with anyone.
Is there, we have, I believe, one besides Pat Gable, I believe Terry Cortones is our other witness. Are there any questions for Becky? Senator Baruth.
So this is a delicate question. I'm not quite sure how to phrase it, but any dispute, correct me if I'm wrong, would be adjudicated in the courts. So how does that work when there's a dispute between the legislative branch and the judicial branch, and it's sent to the courts for adjudication? I would imagine that we've been going at this problem for long enough now that I would have to believe that the judicial branch, every member of it is aware of what's going on and has, in many cases, probably signed on to the strategy that we've seen Pat Gable putting forward. So how would that work if let's say we were to pass this, and would we be sued by the judicial branch and then have that suit adjudicated in the judicial branch?
Yes, I think it would be adjudicated by the branch involved in the dispute. And, you know, constitutionally, the judiciary is able to, they have sort of control over the administration of the courts. So I think their view of this constitutionally is that this is part of that authority to administer the courts, and they are in charge of what that interpretation means. So it is, as you said, a delicate issue, and I guess I'm not sure that I can really comment on
Well,
and how that would go, but I think that is what their argument would be.
I understood. Let me ask it this way: if they really didn't like this bill or felt that this bill was unconstitutional, what would be the actual mechanism for driving it to adjudication? Who would sue, or would it be a suit?
I'd have to think about that, but I think it would be the court administrator on behalf of the judiciary. But can I get back to you? Yeah, can I
Sure.
get back to you on that?
Yeah, it's fine. I mean, I guess it's an insoluble question, especially since there's the policy on the judicial side of not commenting on prospective cases or offering opinions prospectively. So, you know, it's it's something like I've never seen before, where there's this fight between, you know, in effect, lawyers and judges that then the legislature entered into, and now we're reaching a point where we would formalize the dispute between the two branches. And I mean, it's fascinating. I just don't know how it would play out if we pass this bill.
And
But I,
oh, sorry, go ahead.
so no, go ahead, Becky.
I guess I would say that the hope with this bill was that it wasn't going to lead to a dispute, but clarify the legislature's position about what fees fall under the fee branch, the judiciary fee branch request, versus the other section of law about fees that can be set if they're not otherwise specified by law.
But then is Jeanette, just if I could.
Yeah.
But then is it, I thought in the discussion, what we were saying is if they're included in the fee report, then it in effect places it under our authority when they recontract or contract with another entity.
Right, but you have, the legislature has that authority with other judiciary fees.
Understood, but they're saying in this case, anyway, it's a can of worms.
Yeah, I mean, the attempt here is to not impair the current contract in place, but to make this a future requirement such that it can be done, I guess I want to say more in coordination with the fee process set by the legislature.
Can I ask a question about that? Remind me why we what the impetus was for saying that these particular fees cannot be set by the courts. Was it because of the fees themselves, or was it because of the process that we were told occurred without input from the stakeholders?
I think it was a little bit of both. The process occurred without input from the stakeholders, but they relied on the legislature giving kind of a thumbs up to electronic filing a few years ago, and then they went ahead and made the contract.
Right, but I guess my question is why we allow them to set some fees and we set other fees. Why did this particular one come under the under our scrutiny and ask that? So is it because we're reacting to what we saw as the process that didn't include people, or are we reacting to the fees themselves, or are we thinking that this is a fee that even if there had been a stakeholder process and they'd come up with the fees, would we have been doing this? That's my question. I guess I have no answer.
Senator Sears, I think, just went to take care of his dog, let him out or in.
Well, I think he also has to leave.
Oh, okay.
But anyway, that is my question, because if we're doing this in reaction to what we saw as a flawed process, then I'm not sure we should be doing it. If we're doing it, if we would be doing it, even if we thought the process was okay, then I'm fine with it. But I just need to know why we're doing this.
Okay, so if no one,
I guess I can't really answer the why,
Right.
but
yeah, that is important.
But I will say that, I mean, there is a statute that does set forth the fees for a number of other fees associated with the courts.
Yeah.
So So I guess I would say that it's not that this is not done in many other similar contexts with judiciary fees by the legislature.
No, I get that. I just want to make sure that we're not doing this in response to what we heard was a really flawed process, and that we're somehow reacting to that. And if the process had been smooth and everybody agreed with the process and it came out in the end, would we still be doing this? And if we would not still be doing this, then I'm not sure we should be doing it now. If we would still be doing this, then I'm okay with it. If that makes any sense to anybody.
It does to me. I think Senator Sears has stepped away for a second. Are there other questions for Becky on this
Oh,
draft?
and I'm sorry, that wasn't for Becky. That was a pondering question.
Alice,
sorry.
did you have one?
I didn't. I was wondering, oh, Senator Sears is back. That's fine. I was wondering if Terry Corsones might weigh in.
It looks like Senator Benning has a question too.
Joe?
Can we put the down so we can see people?
Oh, I'm sorry. I have two
Thanks.
screens, so I forgot that was even up.
Thank you. Thanks.
Becky, have you had a chance to read Pat Gable's written testimony?
Yes.
You
Have
were
I-
asking Becky, right?
I have
Yeah, I
not.
was.
I have not. I've seen other court positions on this, but I have not seen the most recent. No.
Well, you said that there was precedent for other fees in this nature, and I think one of the claims that she was making was that this is not an actual fee that's provided to judiciary. It's a fee that ends up in the vendor's hands, and I'm wondering if we have any precedent for demanding a report on something like that.
My understanding of most of the fees are ones that are paid to the court. Although I think that's a tricky question to answer because that's also just how the contract is structured. So I can see if there's other precedent for that, but the fact that the judiciary sort of pays them and then they get paid through this, fee is a construct of the contract. So I'm sure that there are other ways that electronic filing fees could be submitted to the court under a different structure.
Okay.
But I can look into that.
I mean, part of the issue that's not addressed here, kind of leading into Terry Corsone's, in my opinion, this has been an unmitigated disaster. The rollout, from what I hear from practitioners all over the state, and continued problems, particularly in the criminal justice system. And I have not heard, and I know there's problems in the civil arena as well. But hearing from the defense, as well as the prosecutors, as well as others, the problems that they've had. And I think even law enforcement's now having significant problems in gaining information. This thing is just, and clearly the court has decided that that we have nothing to do with that. But on the other hand, we still keep getting complaints from our constituencies about it, which is rather frustrating.
Yeah, I want to agree with you, Dick. And I told Peggy before you all got on this morning that I could probably be a witness in this particular discussion, and I'm very frustrated with it. But when I read Pat Gable's 2-page statement, she was raising an issue that seems to me Becky ought to be looking into, whether or not there's a difference between a fee that is paid directly to judiciary or a fee that is paid to a vendor that judiciary hires, I think was Pat Gable's thought on the process. And I'm assuming we're going to have more than just today for conversing on this bill.
Well,
that Pat will be coming in to talk about it.
Well, Bob, but we're against the, problem is we're against the damn crossover deadline, and
Yeah.
maybe I can get an exemption for it and make, get it over to the finance committee to get an extra week, but I don't know what we can do. We've had hearings, frankly, I don't know how much more we can kick this around because we can't seem to solve the problem because it's between the judiciary and the public. And I'm frustrated too. I'm frustrated that we have no power over this. Now, we are paying the bill.
Right.
So at least we're doing that. All right.
Do you have Terry Curzon's on the list?
Yeah,
Yes,
she's next.
Next.
Okay.
Go ahead, Terry.
Great.
Great segue.
Oh, okay, great. Thank you. I'll unmute. And I apologize in advance. I have a bit of a cold, so if I start having a cough attack, forgive me. Thank you, first of all, for all the attention that your committee has provided regarding the e-filing fees since they first surfaced last spring, and for the opportunity to speak today. The bar basically supports legislative oversight of any court fee that Vermonters are required to pay when they utilize the court system. And now that the courts are transitioning to the e-filing system, that includes e-filing fees. And personally, obviously, Becky would be researching the answer, but to me, it shouldn't matter whether the fees are paid to a vendor or paid to the state. There's still filing fees that Vermonters are required to pay if they utilize the court system. And the fee report mechanism provides the ability for the legislature to provide that oversight in terms of all the factors that are evaluated. I did get a chance to read Pat Gable's written comments this morning, and she makes mention of other means that would be available for that. And I don't know what those other means would be. If there are other means, if there's another mechanism besides the fee report that would allow the legislature to have oversight capacity and to look at the same factors that are looked at in the fee report bill, whether it has to do with budgetary constraints or comparable fees in other jurisdictions, the relationship between the cost and the revenue, or policies that might affect the acceptance of the viability of the fee amount. If that's possible through another mechanism besides the fee report, I would say fine, but to the bar, it's critical that the legislature have oversight over a basic court filing fee that's now going to be required of anybody using the court system that's transitioning to this e-filing system. So that's the bar's position. In our view, S39 provides that mechanism. If there's a different mechanism that would allow the same oversight, then I think that's fine, but legislative oversight is key for this. And we've seen all the reasons why when there wasn't legislative oversight or stakeholder input, what resulted. So that's our position that, and I again, whether if we're saying that because the revenues go to a vendor, there's no oversight, then I would think you could contract to have any fee go to the vendor instead of the court, and where would that leave us? So that's my personal view in terms of the need for legislative oversight, and the bar's view in terms of the need for legislative oversight on behalf of all the Vermonters that we represent who are ultimately required to pay these fees. And I guess in terms of Senator White's question about jurisdiction, I mean, the federal courts, I think, would be either the federal courts or in the state courts if there's an issue impacting the individual the Supreme Court members. There are examples of using retired judges or judges that are separate from the issue. If it's the justices who made the rule, then to have other sitting retired judges normally who would hear the case in state court, or another option would be to remove it to federal court and have that court make the decision if it comes to that. I mean, I would hope that there would be a recognition that there's a benefit to legislative oversight over court filing fees that Vermonters are required to pay. So I
Given that,
would not come to that, but if it did, there are processes that could address it.
yeah, I agree. I hope that there should be a way to, I guess the frustrating thing for me, and I don't even practice law, but is hearing from so many different people who are so frustrated with this system. And even though we've taken the financial cost out of the picture by having the CARES Act funding help cover it until April 1st, that doesn't make up for all the frustration that people have with the system as it is. And this bill does not help that at all.
Well, I am happy to report that thanks to Act 120 and those meetings that were set up with court users and the alternative e-filing fee group, et cetera, I think progress has been made. And also just to let you know, there's a Vermont Rules of Electronic Filing Committee that met and has implemented emergency rules that will help address, I think, some of the issues that have arisen. And so we are, I think, making progress. And we're working, for example, at our mid-year meeting, we're doing a joint presentation on Odyssey best practices and on the new emergency rules, Vermont Rules of Electronic Filing. So I think we are making progress to, working together collaboratively to improve it. And it's my understanding that there are negotiations to modify the e-filing fee in the contract. So hopefully that will be for the April 1 deadline. But ultimately, though, I think legislative oversight for whatever e-filing fees there are now and in the future, I think is only in everybody's best interest, to be honest, but especially for Vermonters who are ultimately paying those fees, that there has to be the same review and the same factors that are given for any court filing fees before Vermonters are required to pay them.
Senator Benning.
Terry, you just said that you were in the process of conducting meetings to try to make this work out. My neighborhood, the Kingdom, is the last on the rollout of this system. Up until this morning, I would normally get a case with a docket number attached to it. And the docket number would read something like 101-2-21 EXCR. From that number, I could tell the month and the year that it was filed and what courthouse it was filed in. This morning, I get a document that instead of a docket number, it says case number. And the case number is 21-CR-00911. What county is that filed in?
I understand, Senator Benning. From what I understand of the new case number designation, you don't get nearly the amount of information we got from the old docket number system. You get the year, you get what division it's in, not the unit, apparently, and the number of filings, I think that's statewide, to be honest, but that's my understanding of it.
I'm struggling to, this is just a complaint, and Dick, I'm sorry, this is sort of going off of the bill a little bit, but
it's okay.
I don't understand why we've gone to that system, which deprives any attorney of the ability to ask somebody, what is the docket number in your case? And then they would be able to give that number, and the attorney would say, well, that's in Chittenden County. I don't practice in Chittenden County. The criminal division is statewide. So all I know from this document I'm assuming the 21 at the beginning of it is the year 2021. CR means criminal division, which is statewide. And the number at the end is something that is apparently statewide cases. I don't find that to be terribly helpful. In fact, I find that to be rather absurd. Why would we give up the ability to know from year to year how many cases were filed in a given courthouse?
Right. I apologize. I'm not the best person to answer that. We had asked if the same system, which, as you said, has all those advantages, could have been carried forward, but we were told it could not be, and I don't know the exact reason why.
Matt Valerio appears ready to answer that
Oh,
question or
okay,
pile
good.
on to it.
Well, I hope that he does, because, you know, when the state's attorney here in Caledonia County complains that they don't have enough staff, and I watch the number of cases on the docket system going from 1,200 in year X down to 900 in year Y,
Yeah.
and then down to 700 in year Z, I can see the trend. And I can tell how many cases they've actually been dealing with. So why would I want to give them an increased number of people working in the system? It seems to me we've deprived ourselves of the ability to look at that. Why would we do that?
Why would we do that, man?
I don't know why we do a lot of things. But the, you know, I mean, the system has the ability to, and our system does, the DG system, state's attorneys, all the case management systems have the ability to independently report on caseload and the like. What you're talking about is a more common sense sort of on the fly ability to look at what is going on with an individual case, where it comes from, and what kind of what number it was in line for that particular year. And you did get a lot more information from the old system. And I, you know, that's what you're bringing up is one of the minor issues relative to the system. You know, as you know, our office has worked really hard to try to get people up to speed on it. I think we just finished our 4th or 5th training, and the last one was designed to try to bring in the folks from the north who hadn't been brought in yet, and who had, I think some of them have just been kind of avoiding it for a while, even though we had 3 or 4 other ones beforehand, and I don't blame them. You know, I've had to deal with I had one of our offices as individuals in St. Albans filed a lawsuit to try to stay the implementation of it in their county, and for the remaining parts of the state that were not using it yet. And, you know, to be honest, I prevailed upon them to, you know, back off. I don't think you're going to get very far with this. And I don't think you have enough facts to get an injunction that would make any difference. And you know, they had their choice to make, and they made it and withdrew the lawsuit. But it's gotten to that level of frustration with some, where they just want to do something to try to get the system under control in some way and have some sort of oversight. The e-filing fee is one part that doesn't affect the Defender General system, but it's just one of the number of issues that are a frustration with the rollout. I do think that at some point people are going to become comfortable with this and adopt it, but it really has been a mess trying to roll it out at the beginning.
Matt, can I just say, when you say it doesn't affect the Defender General system,
the e-filing fee.
Well, right now, the state has decided to pay for that. And so we have adopted this ongoing payment need. And I constantly rail about creating new programs when we can't sustain what we've got now. And that's exactly what we're doing here. We are adopting a whole new payment that is going to be required to be sustained in some fashion. So that's one thing. The other thing is I've been through 2 Odyssey trainings. I've managed to get myself registered, I think, because I haven't actually gone through the process of filing my first document. But I'll tell you, I can't wait for the time when I've got to do that. I have to believe I'm going to be on the phone with a court clerk who's going to walk me through the process. And hopefully she's going to know what they're doing, because thus far they don't know what they're doing. They've been struggling to catch up.
Yeah.
I may be
Can I
back to make more
just
complaints.
comment? My understanding of this, it was never going to be a charge to either the defense bar or the prosecution side, that the fees were on other attorneys in civil cases. And if I'm incorrect, correct me, but I thought that they charged a higher fee in civil so they could cover the cost of the public.
I don't know the answer to that. When I learned that the Defender General, if you designate yourself as a Defender General associated lawyer and you're filing Defender General cases, that you would not be charged a fee. And I assume that the state was picking up the tab on that, at least temporarily.
I don't think so. Well, the state is picking up the whole tab right now.
Yeah, it's spread among the private bar and all of the people who could be charged. Any of the criminal cases, whether you're DG or not, you can't charge a fee for defending your constitutional rights, and you've been dragged into court effectively by the state. But you're right. Bottom line is that the people who are paying for the people who aren't, and we do that a lot in government. But that is the case.
I've got to leave. I'll be back hopefully around 10:30, 11. Senator Baruth, if you would continue the meeting. And
Sure.
I may try to log in from up at the vaccination site if I can.
Senator Sears, what's your, I see we're supposed to take a break later, but do you want us, when this conversation has reached its end?
Why don't you just take a break and come back? I believe it's 11:15. We've got other witnesses scheduled.
Okay, sounds good.
Thank you.
So I'm glad the state is not picking up the tab on the one hand, and on the other hand, I'm sort of miffed that we've shifted that cost to other people that probably are not going to be happy about that.
Well, yeah, I don't think constitutionally you can charge people in the criminal system or the juvenile system or the like for it. So, but I guess it's got to get paid somewhere. I understand your concern.
What are we going to do when Tyler Industries decides they don't want to do this anymore?
Well, that's an issue that the DG's office has right now, where we have a case management program that we've had for 7.5 years, and the company that administers it says, look, we're no longer supporting this version of the software. The fact that we got 7.5 years out of it is actually a good thing. But they did a drop dead date of July 1st, 2021. And, if you put things out to bid, there's a big there are transition costs and migration of data costs and all kinds of things that go along with it. And effectively, the company that you've been doing business with can hold you hostage, unless you have major issues with them, you're pretty well stuck with them. And so Tyler Technologies is a huge company that does this stuff all over the country. And they are effectively creating a monopoly on this kind of work. On the good side, they can refine things and they are very experienced with it. On the downside, they basically got you once they get you. And that we're seeing the same thing with our case management program. We're probably, I don't know how the negotiations will ultimately come out, but it's similar factors.
Joe, do you have more?
No, but I will when I get my first document filed, I'm
Okay.
sure.
Terry, do you have more for us?
No, I appreciate getting the opportunity, mainly just to emphasize the bar's support for legislative oversight of e-filing fees, whether it's through the fee report mechanism or if there is an alternate one that allows the legislature to have the same ability to scrutinize and to approve or disapprove. That's what we would favor.
Mhm. Okay, I realize that discussion was quicker than the schedule indicates, but I don't see that we can do much more on this bill without Senator Sears. Does anybody have any objection to adjourning now till 10:30? That's when our next set of witnesses comes in. Or is there something you'd like to take up?
Does anybody know whether this bill is going to have to go through, I'm assuming it's going to have to go through finance before we get it onto the floor.
I would think if it's fees.
Yeah, okay.
Okay, without objection then, let's take a break until 10:30. And Peggy, we can stay on the call and just everyone turn their cameras off and mute?
Yep, and I'll
What-
end the live stream also.
Okay.
Whatever will we do with an hour that isn't scheduled?
Well, that's what I'm saying. It's like a precious commodity.
Yes.
All right. See you
Make
all in
sure
a bit.
you, yep, shut